Voidable contracts. Art 1390, the following contracts are voidable or annulable even though may have been no damage to the contracting parties. Those where one of the parties is incapable of giving consent to a contract. Those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. These contracts are binding unless they are annulled by a proper action in court. They are susceptible of ratification. What are voidable contracts? Voidable or annullable contracts are existent, valid, and binding, although they can be annulled because of want of capacity or vitiated consent of the parties. But before annulment, they are effective and obligatory between parties. Hence, it is valid until it is set aside, and its validity may be asserted only in action for that purpose. They can be confirmed or ratified. Void and voidable contracts distinguish. Void. A contract is inexistent and void from the very beginning when its cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. It is absolutely simulated or fictitious. Its cause or object did not exist at the time of the transaction. Its object is outside the commerce of men. It contemplates an impossible service. The intention of the parties relating to the principal object of the contract cannot be ascertained, or it is expressly prohibited or declared void by law. The action or defense for the declaration of the existence of a contract does not prescribe. A void or inexistence contract is one of which has no force and effect from the very beginning. Hence, it is as if it has never been entered into, cannot be validated either by the passage of time or by ratification. There are two types of void contracts. Those were one of the essential requisites of a valid contract, as provided for by Article 1318 of the Civil Code, is totally wanting, and those declared to be so under Article 1409 of the Civil Code. Voidable. A voidable or annulable contract is where one of the parties is incapable of giving consent to a contract or the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. The action for annulment must be brought within 4 years from the time the intimidation, violence, or undue influence ceases, or 4 years from the time of the discovery of the mistake of fraud. By contrast, a voidable or annulable contract is one which the essential requisites for validity under Article 1318 are present, but vitiated by want of capacity, error, violence, intimidation, undue influence, or deceit. Vices of consent. Contracts which were entered into by a person whose consent was obtained and vitiated through mistake, violence, intimidation, undue influence, or fraud. Thus, contracts where consent is given through fraud are voidable or annulable. These are not void in truth, since voidable or annulled contracts are existent, valid, and binding, although they can be annulled because of one of the capacity of the vitiated consent of one of the parties. However, before such annulment, they are considered effective and obligatory between parties. What is ratification? Ratification or confirmation is defined as the act or means by virtue of which efficacy is given to a contract which suffers from a vice of curable nullity. Requisites of ratification or confirmation. The contract should be tainted with a vice which is susceptible of being cured. The confirmation should be effective by the person who is entitled to do so under the law. It should be effected with knowledge of the reason which renders the contract voidable. The reason which renders the contract voidable should have already disappeared. Action for annulment of contract and action for nullity of contract distinguish. Action for annulment of contract. An action for annulment of contract is one field where consent is vitiated by lack of legal capacity of one of the contracting parties, or by mistake, violence, intimidation, undue influence, or fraud. By its very nature, annulment contemplates a contract which is voidable. What is valid until annulled? Such contract is binding on all the contracting parties until annulled and set aside by a court of law. It may be ratified. An action for annulment of contract has a 4 years prescriptive period. Action for nullity of contract. An action for declaration of nullity of contract presupposes a void contract or one where all of the requisites prescribed by law for contracts are present but the cause, objects, or purpose is contrary to law. Morals, good customs, public order, or public policy prohibited by law or declared by law to be void. Such contract as a rule produces no legal and binding effect even if it is not set aside by a direct legal action. Neither may it be ratified. An action for the declaration of nullity of contract is imprescriptible.